Abom ana esibo so TV 3 Samuel Atta Akyea fire back to Justice Achibonga so ye ni obi bia memma we dia Cabernet video maya me memma na mpa bia mo fasam ne nko Atta Akyea se wo ma ne o ma organ ha nko ba bia bo ma court ne mpese mu ye bia mo nye aden onko no be di chief justice onko na ye judge nhunu ni pasa you can't intimidate anybody hey owie na wuntumi se yesi ande apia ku bia kokase wuntumi ka kire ne sese nya ono panko nyo bedwane enti enne I think no me document attach attorney general a file against the petition of some or the motion for someone attach requesting bail for wuntumi o me hia na 19th and ebuzan say awukro ya za vacation o san the motion ko anya double standard no so kasa kakra deputy ejika asam na subjudice is before the court on kasa but attach him say no wadwa attach him ni unyasa ba no wadwa kakra mebo ni nyina dia ma we be long video ba me view ni meja ma na wa charaje ti make sure so be subscribe down ma subscribe now click bell notification me the video be to be notified we are you have a comment feel free leave that comment in the comment section. You are make sure so be Goldberry Construction Limited do dan episode sin wasasen kratasem anything related to building renovation ni bibia no Goldberry be this age man nyina ma so free Goldberry and I will be a warrior renovation adan ho ne ma bia ma project bia akwantu ho nsem on land wakoto opo be check cross check na ma Goldberry tomo happy bi obi cross check ama wa back home assist on be bia ma on send pictures videos kama offer na as you say to se frɛ no obɛhwɛ na bibia aye kama e dia ma maka tro se judge na ma Achibonga Justice Achibonga ama yewra kwabradu 6 days 17 fa lawyer Brown farmer prosecution witness no jira da kan wo na abetoto na no ti kopo questions bra na answer touch baba no mfra touch chairman yes bra court osebo ma nyom pa bi on fasam ne nko say na deputy agency no so fresi na ne ka tiebi.
We are in the legal vacation, madam, and if you pay regard to the history of legal vacations, it is very obvious that they are not intended for substantial cases before the court like hard-head criminal cases. They are intended that the lawyers will rest, and where there are emergencies, some consequential motions that should have the attention of the judiciary, the vacation judge will sit and listen to the motions. Now it's even become virtual that you can sit in the comfort of your law firm and move your motion for the judge to determine one way or the other. So we do not understand why, in the name of expedited trials and ambulance trials, some special courts should sit to deal with some special cases, probably to achieve some special ends. We don't understand it. And we wouldn't lend our support to what we see as a complete aberration of the known practice of the courts. That during legal vacations, the lawyers rest. And that is why there are mass of murder cases before the court, rape cases,
I see,
manslaughter cases, stealing. They are all criminal cases.
So, counsel, just so I understand,
the judges who are conducting these cases are resting, and so are the lawyers. So this selective, arrangement at the instance of the CJ leaves much to be desired, and that discretion, we might want to question it.
So just so I understand, you're saying that your absence today is in defiance of the CJ's orders, that certain cases should be heard during the legal vacation, correct?
Certainly, that is what it is.
I see. I have the Deputy Attorney General here who has written that, look, the legal vacation is not for lawyers. The legal vacation is actually judges' vacation and not for you lawyers. And no lawyer should be telling the Chief Justice that they need to rest. And so some cases should not be called when the Chief Justice chooses otherwise. Dr. Justice Shremsai, how do you respond to what you have heard from lead defense counsel on the Edubuahin case when he says that I wasn't in court today because it's legal vacation and I should be resting?
Thank you very much. The question is not whether counsel is tired or not. If courts were run based on the tiredness of individual lawyers, you can imagine what would happen in a democracy. So Whether counsel is tired or not, no one can take that away from him. The issue is whether a court proceeding should continue simply because counsel says he's tired. And that is where we are of the view that the tiredness of counsel or counsel's private circumstances need not determine whether a case will be heard in court or not. Now, secondly, there are situations where lawyers may have genuine reasons why they cannot come to court. And it may even be true that tiredness may be one of such reasons. But the solution to that problem is not to say and sit in your office and say that you will not attend court because of legal vacation. If a counsel has a problem or is tired, what counsel needs to do as far as the professional law practice is concerned is to appear before the judge and make a case for an adjournment based on the circumstances. Then the judge will consider your plea, and judges have always done that, whether in term time or in vacation. Judges always consider counsel's circumstances in adjourning cases, and I can say on authority that I'm in a couple of cases with my good friend who is the defense lawyer here, Lawyer Atta Akyea, where adjournment has been given, where proceedings have been cut short because of his personal circumstances, where he needed to attend meetings, where he needed to attend to family reasons, adjournment has been secured. So to create the impression that it is because he is tired that he doesn't want to come to court will be a wrong way to look at the issue. Now, secondly, counsel, I understand him to be saying that it is only his case or some specific few cases that are scheduled to be heard in the vacation. That is completely false. And you see, that is a deliberate twist of the facts to create an impression that a system has been set up to persecute some particular individuals. The practice of having cases heard during legal vacation is as old as the judiciary itself. It begins from England, and now we practice it in Ghana. It is something that we've always done. And if you follow what conversation is going on, there is evidence that judges from 2011, for instance, Chief Justice Georgina Wood has actually asked commercial court to sit throughout the vacation. There are instances where the previous Chief Justice, so it is a normal thing. The impression being created that some persons are targeted is completely false, in the sense that, you see, there are a number of vacation judges. Oral cases are not before only these judges. There are oral cases in other courts. Those courts, the judges in those courts are not appointed as vacation judges. Therefore, those cases are suspended because the judges are not. And in respect of these judges, they do not only do oral cases, they conduct other cases, like he's mentioning. Some of them conduct robbery, rape, and other cases, and those cases too are ongoing. So
Doug, just to get the point straight, what you are telling us now is that the legal vacation is not being used to hear only high-profile cases.
At all.
So there are regular cases being heard in certain courts, not interlocutory, but substantially.
Precisely.
Okay, right.
Yeah.
And then it takes me back to the defense counsel in the matter of Kwabena Dubois in court. Counsel, you left your client in a bit of a pickle when you decided that you will not go to court today. What we are learning is that you could have gone to court and then put in a plea with the judge that you needed that needed to be accommodated before then leaving the case. Why wasn't that an option for you?
Because I have petitioned the CJ. The decency of engagement is the CJ that gave the warrant to the judge to continue with the case. So the judge should have stayed in hands and to hear what the CJ will say. That's the decency of everything. You see, so the judge cannot say, okay, I've not heard from the CJ, although you've petitioned from the CJ, but I'm giving you next week, come and do your own case. Please, we should stop this kind of, engagements, so that people will turn around and say somebody is showing disrespect to the judge or whatever.
Perhaps
so who gave the warrant? The CJ. The lawyers have petitioned against the warrants issued by the CJ. Shouldn't we say that let's abide the outcome of the determination of our petition to the CJ, and the case should continue. So how can a lay person cross-examine a witness, the prosecution witness? It's such a critical case. How is that going to be done? Are you not subverting his right to counsel? And when counsel,
how is that subversion of right to counsel when it's you that did not show up in court?
You see, sometimes I love to scorn when people believe that lawyers do not have the right to challenge what authorities say. I am not running away from the court. There is an aberration I'm fighting. I do not see how some cases are not slated. The Honorable Samuel was even given an impression that there are cases that they are doing part heads. You should name the cases. Aside these special ones, that the judges are ready to do part head cases. If people have learned cases, and in the wisdom of the rules of court, we should go on legal vacation. What is the superiority of preference? Now let's do these special cases. And the land cases and the murder cases should go to bed until October. That is selective justice that the Constitution frowns upon. It's obvious. What is special about these cases? What is the emergency about these cases? That they can't abide our return from vacation, everybody's refreshed, and we continue. You're giving everybody an impression that, look, these cases are of priority to you. Why should some cases be of priority to the CJ and not others? This two-track system in which some cases are of no consequence but others matter to the CJ undermines totally the rule of law, and we got to challenge it. Not that anybody is running away from the case. I've been very faithful. You talk to the Attorney General in the prosecution of this case. I've never absented myself once. I've never been to the hospital. He will testify. I'm not running away from my favorite area, litigation. So what is the point? But what is the emergency about this? They can't explain.
We'll have Doug look at that. But before we go to him,
I will not violate the traditions of the practice that we are clear that we should rest, but we are giving oxygen to a special arrangement in which some people who have been arraigned before the court, not on interlocutory matters. You rightly said it, but on full trials that continually is unfortunate.
Let's go back to Doug on the matter of urgency of the cases, because besides you making the assertion that this is selective justice, because you do not believe that regular cases are being heard substantively, the AG has said that is not the case. You're also raising the matter of what is the urgency about these particular high-profile cases that need to be heard during the legal vacation. Doug, what's your response to that?
Yeah, thank you very much. It is unfortunate that even after I have informed counsel and assuming that he didn't know that there is no special treatment for these cases, other cases in these vacation courts are being tried and heard, he still goes on to insist that, to say the thing that he has no knowledge of, which is also not true. So clearly, I am convinced that the purpose of these issues, the purpose of doing what counsel has done is not genuine. It is to perhaps just use this to achieve other purposes. For example, one of the things that we learn in law school, okay, as ethical, is that a lawyer, when you are representing a client, should not avoid the courtroom and use other means to delay court processes. But that's what is happening. Look at what the situation is. There is a date for hearing. It was determined you were in court when the date was agreed. Now, you have written a petition to the Chief Justice, and your argument is that until you hear from the Chief Justice on your petition, you will not go to court. But is that how it is done? Even we know that even when you apply for stay of proceedings, until it is granted, the case continues. So on what lawful basis would counsel say that he decided not to go to court because he's waiting the decision of the Chief Justice on his petition? The right thing, as far as my understanding of practice is concerned, is to appear before the court. And even when you go to the court, you can still tell the court that, oh, because I have made this application or this petition to the Chief Justice and I have not heard from him, can you indulge me to hear from the Chief Justice? That is what we are taught to be done. But to refuse to come to court and say that because you have taken some other process and you have not had an outcome, so you will not appear before the court. I'm not sure that is what, as the second person who leads the bar, I'm not sure that is what I would recommend as a proper or a good way of representing a client. And I think you are very right when you said that his decision to not attend to court is what is making his client suffer. And I think that is exactly what it is. If you have anything, and I have always maintained that judges throughout the country are reasonable people. Even in term time, we all go to court and we sometimes ask favors or basically give reasons why cases should be adjourned or should even be truncated because of our personal circumstances. And I can tell you, judges most of the time will accommodate that. Counsel on the other side will accommodate that because we are human. What this case is presenting is to put the decision whether a case should continue in the hands of a lawyer to decide that I will not come because I think that I am not supposed to come, which is not what the situation should be.
I'll have Counsel Atta Akyea respond to that. But while you come on, gentlemen, I just want to say that we have heard from the Chief Justice on this matter. He's upheld his earlier decision to call certain cases during the legal vacation. I want us to take a listen to the Chief Justice, and then Counsel Atta Akyea, you respond to that briefly for me.
Okay.
To write to the Chief Justice to say that the cases should not be, adjourned to the vacation. So I am not coming. I have already made agreements outside, so I'm not coming. You are a lawyer. You have your clients. If your clients decide to leave, well, go on leave. But you cannot say that there's a legal vacation and the judge who is actually sitting cannot do your case. No, that's not it. And then adjournments are not at the instance of the Chief Justice. An adjournment is a judicial act. This is something that is so basic that sometimes when people write that I got a letter saying that I should withdraw the direction and also direct that the cases should be heard in the third time. I said, you went to court and the judge decided that she was right.
Counsel, you heard him. He's very clear.
It's not clear to me at all. But you can tell me, what is he saying?
Well, he says that, first of all, that instance is the instance of adjournment does not come up onto him. But he's also said that you cannot say that lawyers need to go on vacations, though the judges shouldn't work when there is work to be done. Essentially reiterating what Dag has been telling us this whole time.
No, why are all the courts not working? Why are some special courts working? It's not selective justice.
No, but
what discretion is that? That some cases are very special to the CJ, and therefore let's all rush to court and do them. The rest of the cases don't matter. Let's all rest until we come to October.
How is that your conclusion? When we have agreed that cases being heard during legal vacation is not new. The example of Justice Wood was given when commercial cases were heard during...
What commercial cases are part heard and being continued? Let me know. What are the commercial cases that are part-head? Do you understand part-head cases? And can you fix part-head cases in vacation without the agreement of the lawyers? Is the judge sitting by himself or herself without the convenience of the lawyers? What is the meaning of legal vacation? Even the linguistic evidence is telling you that we are on vacation.
But you've been told that the legal vacation is for the judges, not the lawyers.
The Court of Appeal is on vacation. If you want to have judges sitting, it relates to emergencies. So you bring a motion, and even now it's virtual. What is special about these part-head cases? That at all costs they should be heard. At the great inconvenience of the practitioners. We don't have to rest. For what? What is the basis of that? Is it not in violation of the Constitution? So I don't understand what is going on, but you see, I don't have to come to court and persuade any judge that, well, I will not be able to continue with the case. Let me hear from the CJ. I've stated in my letter to the CJ, copied to the registrar of that court. That I'm
Right.
not
So,
coming
so
to court.
counsel, here's another angle you haven't looked at. Why are you not in a hurry to clear your client's name?
Who tells you I'm not in a hurry to clear my
Well,
client's
you've been
name?
given an
Is it
opportunity
not
to work
ministering
during
you
this
that the whole
period.
year I've been working?
Say that
Has it
again.
not told you that the whole year, when was the time that I said I won't come to court? And you believe that I shouldn't have my vacation as the CJ is having his vacation? What is the meaning of legal vacation? If you want to go and read the law, go and pay regard to Order 79. And Order 79 decrees legal vacation. What is the meaning of legal vacation? When a studio is on vacation and you say that, oh, there are some special cases that they should come in here, you should justify it. What is special between what a murder case and Cabinet Dubois' case? Why are the murder cases not being heard?
What will be justification enough?
What will be justification enough? Somebody's pleasure, unquestionable pleasure, a fetish of a pleasure, that these are special cases by my own thinking. The rest of them, they don't matter. You think we can't question discretionary powers, administrative decisions? They are all embedded in the Constitution. Yeah. What are you feeding the public? Why? Why are we in an ambulance mood to try these cases? The rest of them don't matter. What is the point of the matter? That lawyers should not rest because to the mind of the CJ, these are special cases that should be heard. What is the point of that? I don't understand that.
The judge says in 6 days you should be in court, or Cabinet Dubois without legal representation will represent himself. Do you plan to go to court on August 17th?
I'm not going to court at all. But what is informing that? Why should a judge in a very technical case of this nature, that a man's lawyer is on vacation and the judge is saying that if your lawyer doesn't come, go and find another lawyer. But he's saying that you come and stand there and cross-examine. How can a lay person, cross-examine in such a matter? You are asking a carpenter to go and do a surgery. Is
Then
that
go
how it's
to
done?
court.
It's not. Sorry?
Then go to court.
For what? For what? Why should I go to court? What is the meaning of legal vacation? What is special about this case? Some of these things you are failing to answer. And I know they can't answer. What is special about these cases? When we try these cases in the vacation, the inflation of Ghana will go down. What are we saying? What is the emergency about these cases? They can't answer.
Yes. No, we don't say, Kewo, want to me also copy bail man 19 debate emotion. And then double standards yet any answer.
So I want us to look at the Untumi bill hearing today. What the Attorney General's office has said is that, look, not only are the reasons you put in your affidavit not reasonable enough for any chance of success, but also your client is a flight risk. And the reason they say that is because his former counsel has said on a media platform that but for his own advice to Chairman Wontumi, he would have left the jurisdiction of this country. How does this come to you?
Well, I believe this, as cathedral issue should not be part of the thinking of any serious judge. As a matter of fact, I do not know the validity of this matter outside the court. But a man is a flight risk, and 9 good months, he never absented himself in court. He came to court. Wontumi was faithful to the hearing of this action for 9 good months. So what is it? What is it? This business of is a flight risk. So please, I would rather you spend this discussion in the media space regarding a very valid application I've filed. And let's come to court. I've not received the affidavit of position from the Honorable Attorney General's office. But if I should get it, I know what to do. But for anybody to now begin to raise, extra legal matters, it leaves much to be desired. It will be very, very unfortunate and dangerously prejudicial to what we are about to do on the 19th.
Very well.
And on the 19th, we are not going to do a part here. It's an interlocutory matter. I was glad you used that expression, interlocutory. It's not a final thing. Nobody's going to adduce evidence. And probably you might even do it virtual. That is the point of the matter. And that's the difference between
I won't risk it and ask Dag a question as well. And Dag, feel free to have your final comments on the conversation around legal vacations. But when in that affidavit, the Attorney General's office puts that you thought that Chairman Wontumi will be a flight risk if he's released on bail based on third-party information. Why is that important to you?
That's important to me?
No, that's for Dag. It would appear his connection to us is frozen. Doc, did you hear me?
Sorry, I didn't.
Very well. So I was just saying that you could have your final words on the conversation around the legal vacation. However, I'm also risking a question, or based on the affidavit I have read regarding the opposition to Wontumi's bill. And my question is why the acknowledgement of a comment his former counsel made about he wanting to leave the jurisdiction at some point in time is important information to you as you oppose it, considering it is not first-hand information you have gathered, but is based on someone else's narration.
Dominic, can you please do me a favor on this one? Since this matter is yet to be heard in court, I would beg that I do not comment on it.
Yes, Professor Chese, send him a lawyer can. It's mostly for but on also instance I substantive cases. And you know, I think that as I said in the first video, they should find a way to come to a common ground. It's a very emotive thing. It's a very, very emotive when it comes to these cases and all that. But hey, me, I've already shared my view on most of these matters. What do you make of it? Samuel Atta Akyea right? Did the AG also convince you? Feel free. Wherever you disagree, wherever you agree, but in decorum. Now, Janessa in the comment section. We are no subscriber. Most subscriber no click the notification. The video be at 100. Make sure so see them on me here. Ghana and see here. Bye bye.